So I don't have a PowerPoint, so apologies if you're like really big on PowerPoints. My name is Joshua Crook. I'm from the University of Adelaide, Adelaide Law School. And I have the unenviable task of summarising the history of legal education in 15 minutes. So I'm going to do my best at doing that. And I take it as my starting point, aside from a brief foray into the Middle Ages, the late 1800s as kind of the base point for this. So, and the kind of overall view that I want to present is this idea that legal education has kind of shrunk in terms of innovation and experimentation over time, and that with the emergence of more and more rules and systems and regulations, there's been a contraction on what law schools can do and the freedom that they have compared to the earliest law schools, which were highly experimental and vastly different to the kind of law school that we're used to today. So that's kind of the general thesis. So let me start in the Middle Ages. So the teaching of law in the common law is commonly said to have started in England in the Inns of Court, which were a group of kind of law, it's almost like a law society, if you like, that was attached to the courts. And so what would happen would be lawyers would come and teach students the law, and students would be able to go and observe court cases, and students would be able to do mock trials. So mock trials and these sorts of things, we consider them quite new, but they're actually very old. And that idea of clinical legal education, which is kind of had a resurgence, is actually seen in some of the earliest examples of legal education in England. So that's kind of an interesting point. The other thing to mention with this is that it was a residential system. So students lived at the Inns of Court and they were trained by lawyers there. So kind of a very different system, more of a kind of college-like kind of lifestyle, I guess, compared to what we understand as law schools in Australia. So the next step is to look at what really happened to start off legal education in universities was the creation of a law degree at Oxford and William Blackstone. So Blackstone is famous for his commentaries, which you're all aware of, but he also kind of was the prototype law lecturer, I guess, and kind of the first person to kind of enter the field of teaching common law as a practice to university students. And so his approach was also very different to what we might understand today. His approach was a lecturing style. He taught on the basis of his commentaries, but he taught mainly about legal principles. And he didn't teach case law specifically. He taught case law, statute law, and legal principles. And he spent a lot of his time talking about problems in the law, law reform, and these sorts of things that are considered almost sideline issues today, perhaps, in the kind of traditional law school. So that's kind of an interesting aside into how he did things back in the day. And what you see when you go back and you look at the history is you see the same sort of thing at every single law school. The initial lecturers tend to be very open to teaching a very broad idea of the law, a law that encompasses case law, statute law, law reform, critique of the law, and a jurisprudential or philosophical approach to law. And that tends to contract over time as the law school becomes more established, more rules come into place, and more systems come into place to govern teaching and what is taught. So if we go to the first law school in America, we're talking about 1779, and something that a lot of people don't know is that the first law school in America was established by Thomas Jefferson in partner with his the person who taught him law because he studied as an apprentice. So there was the apprenticeship model. He was taught by a guy called George Wythe, and so he established the first law school in America in Virginia. And his model of teaching, well, he didn't teach, but the model of the law school that he established was similar to his own education, which was considered a broad liberal arts education. So George Wythe was very big on the idea that you would read things like Blackstone's commentaries, but you would also read, and some case law, but you would also read foundational texts of political philosophy. So you would read Thomas Hobbes and Rousseau and all of these kind of classical thinkers. And with those, you would form a kind of a political view of the law in practice. One of the things that he did, which was highly experimental, and I don't think has been done again since in the law school, is the idea of a legislative assembly. So students were part of a mock legislative assembly where they would go and create statutes, and they would argue over law reform and statute law in a similar way that you would argue over case law in a mock trial. So that was kind of seen as highly innovative, highly experimental, very different to what we hear of today. And it was this direct relationship between the law and politics. At the time in Virginia, almost every single law student would go on to serve as a politician. And so much more so than today, almost like closer to 100% than 50%. But a lot of the law students would go on to become president and kind of governing officials in the government and judges and these sorts of things. So they were seen as a direct relationship between law and politics in the sense that it was intrinsically related that the students would go on to kind of govern the nation in that way. Which again is kind of an old-fashioned view of the law compared to how you see students practicing law today. 50% go into private practice, at least from the major law schools, and a lot of others go into business or other systems. Our parliament is only 14%, I think, law graduates. Our prime ministers are heavily law graduates, like almost all of them. Kevin Rudd is a rare exception. So that's kind of a brief foray into that early period. Now, the time that law solidified in law schools. Do you have a question?
I'm really tempted. How many female students in this period?
Oh, like almost no female students. No female students. Yeah. So you're right. It's a very different. And there was this idea of creating gentlemen or something. A lot of these ideas are very old-fashioned, kind of sexist and racist ideas were kind of implicit in some of these early law schools as well. In the late 1800s, there came about a guy called Christopher Langdell at Harvard who established the case method and the Socratic method. And his idea was that you could teach law as a science. So this was a new idea. Instead of teaching law as an art, which is to say that law comes from society or social forces or something like that, or political forces, you would teach law as a science of rules to be studied unto themselves without any regard to extrinsic evidence. And he formulated in his classes the first case book, and he taught by way of cases, and he said that you would learn law only by looking at the cases and you wouldn't look at anything else. And he was backed up at the time by a guy called Hans Kelsen, who said that law should be rid of the baggage of the social sciences, which I think is a neat phrase. And he said that you should study pure law, which is the idea that you could study every single aspect of law. Every case is reinforced by a previous case, and the highest level of law, the Constitution, can presuppose its own validity. So you don't have to ever look outside the law for any answers ever. You just have to look within it for all of your answers. That became the dominant idea of legal education in the early 1900s. It swept America. It came to Australia in the early law schools in Australia at Sydney, Melbourne, and Adelaide. And it became kind of a dominant idea of the law, which kind of still exists to this day, that one of the main things that you should study in law is cases, and you can understand everything by way of studying those cases. And looking outside of that is kind of a bonus, or an alternative, or an elective, if you like. So there was some resistance to this idea at the time. And one of the most interesting forms of resistance is someone who doesn't get remembered much in the histories, who is the first dean of the University of Toronto Law School. And he was a guy called W.P.M. Kennedy. And his idea was that you could teach law as a social science by looking at it as a form of a liberal art. And he reintroduced the baggage, if you like, of political philosophy. His law students had to do a political philosophy course a moral philosophy course, an extension political philosophy course, and they had to do a kind of a broad foray into the background behind where the law comes from. And he was very interested in the idea of law coming from society. He established one of the very early academic journals that looked at how the law was influenced by social forces with the Toronto Law Journal. So his idea was very interesting because he stated as his explicit intention that his law school had no professional ends to serve, which is to say that he didn't want to teach law as a vocational pursuit. He wanted to teach law as an intellectual pursuit in some sort of vague conceptual sense. This was highly ironic because a lot of his graduates went on to become lawyers, and some of them became, well, one of them became the Supreme Court Justice of Canada, and another one became the Prime Minister of Canada. So it's kind of an interesting situation there. We have a non-vocational degree producing vocational students who kind of excelled in the vocation, which how do you put it, undermines the claim that you have to have a purely vocational degree to produce vocational students. I think that's a false claim. I think you can have a non-vocational degree that produces students who excel in the vocation if they are able to think in a kind of lateral way and bring that into their practice as a lawyer. Okay, so let's kind of jump to Australia in the 1990s. I told you this is a very brief history. So Australia in the 1990s adopted admission requirements for law known as the Priestley 11 in 1992. And so the Priestley 11 are 11 compulsory subjects. They don't have to be taught together, but they usually, they don't all have to be taught as individual subjects, but they almost always are. So you have 11 distinct compulsory subjects in every law school. This is really interesting because in Canada, the same thing happened in, sorry, I have to check my notes, 1957, so a lot earlier. They introduced 11 compulsory subjects. The law deans had like a revolt, and they reduced that from 11 to 7. So that's really interesting to consider that the law deans thought this was a terrible idea to have that many compulsory subjects, and they managed to reduce theirs. And it's interesting to consider comparisons between this and other jurisdictions. In the UK, they have 5 compulsory subjects. Arguably, they will have 4 when they leave the European Union because maybe they don't have to study European law anymore. And in Canada, as I said, they have 7. In the US, there are no compulsory subjects, which is very interesting. There's kind of a vague guideline that maybe you should do something practical, but there's not an enforcement. It's customary, if you like, to have the first year of law school adopt the same kind of look at each law school, but there's no enforcement of that in an explicit sense in the way that there is in Australia. So let me briefly summarize. What happened with the introduction of the Priestley 11 was the introduction of almost all black-letter law case-based subjects as the core of the curriculum, which means by doing that, you threw out the baggage, if you like, of the social sciences. You didn't have introductory subjects to political philosophy. Legal history became kind of passé and was abolished at almost all of the universities. All of the kind of corollary subjects, legal philosophy, legal history, jurisprudence, those sorts of things were slowly abolished at almost all of the universities. And you had a kind of force propelling people towards vocational law and the teaching of students in that vocational mindset, which I believe has not changed to this day, despite huge objections that everyone says when I say that, because despite the attempt to have innovation and experimentation at places like UNSW, which is the social justice university, and other universities around the country, UTS is trying to claim the mantle of being the legal technology university. All of these things are really interesting, but the reality is that your core subjects are 11 subjects, almost 2 years of the education, limited in a specific way, with only experimentation in electives in a final year. In a double degree, that means the 5th year of the student's education, which is a really long time. And that's basically my summary of